And good morning to everyone from our part. As Natalia said, I'm with HEUNI since the beginning of this year and a forensic psychologist by training, which might be heard in the presentation.
Yes, and thank you for the invite. And I'm happy to be here. My name is Immonen. I'm a district court judge, but currently work at the National Courts Administration here in Helsinki, or in Finland.
And we'll talk about encounters in the legal or in the criminal justice process. We start with talking about the pretrial investigation in particular, and then Nina will go on to talk about encounters in the courtroom, and we will raise some important questions that we think should be given more attention than what is the case today. Just as an beginning, we know that we disagree, but let's continue here. Then we do know that witness accounts are often, witnesses' memories are often the core data that is used in criminal justice processes, especially in cases of serious crimes against persons, sexual offenses or violence in close relationships. And these memories are often hard to talk about. They can be difficult and indeed traumatic, and we also know that stress in the investigative interview situation or in the situation where these memories are dealt with severely can hamper witnesses, victims' possibilities to tell about their experiences, which may lead to less detailed, less reliable evidence than to be assessed in court. Much can be done about this, however, and of course this is not the way to deal with these investigative interviews. Instead, there are several evidence-based investigative interviewing methods that have been developed throughout the world and that are in use in some countries, not to a great extent in Finland, and in most of Europe, not so either. However, for example, in Norway, during the last years, there have been quite rigorous, how would you say, renovations of the way investigative interviews are dealt with, and now it is already a habit that investigative interviews are video recorded and that police are trained quite significantly in conducting these investigative interviews. This is a very topical subject in Finland. Just yesterday, there was a big article in the main newspaper, Helsingin Sanomat, about the fact that police in Finland are not trained very well in investigative interviewing. And this is, unfortunately, my impression is this is the same in many other countries. In the UK, for example, though, investigative interviewing has been trained for decades already, according to evidence-based practice, and they have been video recorded. And this is really necessary to stress because we know that memory fades over time. This has been known since 1885, when the German psychologist Hermann Ebbinghaus for the first time was able to show in a laboratory study that our memories fade actually very quickly after we experience or witness or something. And this, of course, goes for crime victims as well, implying that memory should be collected as soon as possible after the events and in a way that is as unstressful, as memory strengthening as possible. We also know that crime victims pay dearly if this is not the case. This is just one of many studies showing that, for example, rape victims whose witness accounts are not taken on video but are taken months and sometimes years later in court actually lose out quite much of the detail of their accounts. In this study, as you can see, losing 2/3 of the story, the title tells it all. So it is quite clear that the practice should go towards recording evidence and then going back to that evidence in court. And maybe the last thing about recording, it's quite clear also that the academic, the scientific world is heavily recommending video recording of witness and suspect and victim interviews. It is not only reassuring that the victims' and witnesses' memories are preserved as well as possible. It is also a means of ensuring that suspects are treated fairly and that police interrogations are conducted without in appropriate ways. And this has been, for example, endorsed by the relatively recent so-called Mendes principles. So the international community is also now behind this recommendation. Then moving on to court, Nina, how do these things look there?
Okay. Thank you. It's always so interesting to listen to you, Julia, so I was just relaxing. Yes, but what's the situation like in the Finnish court today? Well, we are up and coming, I hope, but it's quite recently we've acknowledged the importance of encounters, the concept of the encounters in courtroom settings. And I think the awareness has arisen thanks to collaboration with HEUNI and with psychologists and your field of science. So thank you all. So what does this mean? Actually, so we have started to, like I said, it's a good starting point to have awareness that this is something important. And now we have tried to create the professional training of the judges to more enhance something called judgecraft, which could, in my opinion, include several of these topics, how we encounter people in trials, in court settings, both oral, both spoken language, but also written, and it's a fairly vast issue, but baby steps. We're starting out, and. The human-to-human encounters, I think this is mainly, it's something that we need to have a new kind of approach, a new mindset to. Judges or professionals tend to just see people, witnesses, as some kind of tools, if you may, to get the information needed for our work to be done for the judgment. And of course, this sounds crazy. We shouldn't think this way. And why not? Because, yes, like Julia said, people tend to talk more open-heartedly, much more in detail when they feel they are met in a proper way and they feel safe. And this is, of course, this has an impact on the quality of the evidence and the testimony, obviously. So, and for the general sense of fairness and the public trust in the judiciary. So these are the underlying hardcore values we have to gain for the individuals, but as the system as a whole. And then I'll just say, I'll have a few more points to tell you more about what this might, or what we think this kind of training should include. So, and the mindset, like the new mindset. So, first of all, preparation. So I mean the judges, the professionals, need to take a step back the day before, the week before, the month before, prior, and think, is there something I should be aware of in terms of vulnerability or some special needs or language, cultural references, you know? Is there something I need to process beforehand? So that's one thing. And the starting point, of course, obviously. And then, of course, a lot comes to communication skills. And like I mentioned, both spoken, simplified instructions, clear, accurate language, no jumbo mumbo legal, lingo. But this is quite obvious now. But then listening skills, like you mentioned, this is something we should be work on. We should be much better on, I think, to really listen. So people have the sense that and the feeling that they have been heard. Then something, emotional competence, and to be able and to understand the role of the chairperson, the judge, in creating the setting and the atmosphere in the courtroom, and also regulating it. So this is something we're not very used to. So I could go, but of course, surroundings, settings, enough time, enough breaks, of course, to have some. So safe environment that I mentioned already. So these are just some of the things we need to be better at, and all of these might help us in the future, at least, to be more aware of not to cause any additional damage, not to hurt people, not to add trauma to trauma. So these were some of my thoughts on this.
Thank you, Nina. And I think many of these are not incredibly hard topics to deal with, but they are crucial. I think many of us who have experiences from the courtrooms know that the atmosphere is hardly described as relaxing, most of the time at least. And indeed, maybe relaxing would be too much to hope for, but at least not more stressful than it necessarily has to be. And if we look at advancements in this regard, in Finland, I think one of the maybe success story would be too much to say, but one of the areas where there have been very much efforts during the last decades and also quite a lot of advancements is the area of interviewing child victims and witnesses in the criminal justice processes. We have now for almost 20 years developed recommendations and trainings for the professionals who conduct these investigative interviews. And in Finland, as in the other Nordic countries, but unlike many other European countries, children are not cross-examined in court, but they are heard in the pre-trial investigation on video, and this video is used as their evidence in chief in court. And we do have evidence from other European countries, for example, Scotland, showing that when children are indeed subject to cross-examination in court, it severely hampers their possibilities to give reliable accounts, which is not surprising. So there are models that do seem to work, and it's also to say that not everything is going in the wrong direction. Then we also have a recent common research project with HEUNI and the Courts Administration, Åbo Academy University, and the University of Tampere, where we looked at how judges have experienced remote hearing now during the pandemic, where everything was forced to be online. And just maybe it could be briefly stated that there is quite a lot of research and experience throughout the world of remote hearings. And for example, research in Australia has shown that experiences seem to indicate that remote hearings can indeed be a
safety factor.
Yes, and a factor that de-stresses the situation for the victims. Here, maybe the discussion in Finland about remote hearings have been very much focused on savings and on pandemic measures. And our colleague Inka Lilja, who I'm actually replacing at HEUNI right now, wrote an interesting article together with her colleague about this, stating that remote hearings can indeed be a victim protective measure, and it should not be discussed only from the saving point of view. Also, it was interesting, we of course let the judges give free responses in our survey, and it was quite clear that district court judges in Finland seem to be quite favorable of video recording important pre-trial investigative interviews. So those are sort of greetings from the Finnish judges. Do you want to add, Nina, something about the remote hearings?
No, I think you covered it, thanks.
Okay, then time for a quick conclusion. So Some of the things that we really think should be dealt with is to develop the way in which victims, witnesses, suspects are interviewed in the pre-trial investigation and how the evidence is collected, implying video recording, and make sure police are aware of the importance of these encounters, of how memory works, how people are able to recall traumatic memories, how suggestible, for example, adolescents are, which has been under-recognized. And also then in court to make sure that we treat people with respect and maybe try to train judges in, what did you say, psychological competence.
Emotional competence, amongst other things.
Yes. So I think that was the message we had today. In short, thank you for your attention.
Yeah, thank you.